Hi everyone, good morning. This is Shivani, and today we're going to talk about the doctrine of due process of law. So, the doctrine of due process of law, what is it? Another constitutional doctrine that prohibits the state from taking actions that shall deprive an individual from their rights to safety, liberty, or life. This doctrine has come from the origins of the English common law and was first seen in the Magna Carta, which is the law of the land for England. In the Indian scenario, the doctrine of due process of law isn't implemented in the whole sense. The words in the constitution are procedure established by law, which is borrowed from the Japanese constitution, which is done by the drafters in order to reduce the ambit of the doctrine and reduce the uncertainty. Procedure established by law states that the law has been lawfully enacted if that law is valid, even if it violates the justice, equitable ideals. The tight adherence to the legal procedure may risk the person's life and personal liberty and thus may jeopardize it. Now, however, this interpretation of the courts in the country will obviously eventually changed, and to avoid the exploitation of the words, the Supreme Court highlighted the importance of the doctrine of due process. This change was first seen in the case of Maneka Gandhi versus Union of India in the year 1978. So, what can we understand by the basic difference that comes under Article 21 of procedure established by law and due process of law? What we'll know the difference one by one. First is the procedure established by law. It signifies that if the method for establishing a law has been followed correctly, a law that has been duly enacted by the legislature or the body in question is valid. Due process of law checks whether the law enacted is fair and not arbitrary. Judiciary assesses the process of legislation and competence in the procedure established by law, whereas in the cases of due process by law, if the Supreme Court of India finds that any law is not fair, then it will declare it as null and void. In due compared to due process of law, the scope of procedure established by law is extremely narrow, whereas the due process of law gives a very wide scope. And the state, in the case of procedure established by law, can deprive the basic rights if the procedure itself is established by law, if the right to life and personal liberty can be taken away from a person as it is not an absolute right in the cases of due procedure of in the cases of procedure established by law. Whereas in the case of due process of law, the state must respect all the legal rights that are owned to a person. So, in order to understand this, we have to see the evolution of this doctrine of due process of law to certain case laws. The very first case law that came into picture was A.K. Gopalan versus State of Madras in the year 1950. A.K. Gopalan was jailed in Madras under the Preventive Detention Act. Though through a writ petition under Article 32, he challenged the Act's constitutionality on the ground that it violated the freedom of movement under Article 19, Clause 1, Clause D, and personal liberty under Article 21. In this case, the Supreme Court held that literal interpretation of the words procedure established by law declared Preventive Detention Act to be constitutional. And further, it also went on to elaborate the difference between the doctrine of due process and the procedure established by law. The court said that it is clear from the drafting committee of the constitution that in respect to Article 21, that Constituent Assembly formally used the term due process of law and later dropped it in favor of procedure established by law. The procedure established by law must definitely mean that the procedure of law which is established by the state. So, this doctrine of due process of law was not enforced in India as A.K. Gopalan case later on became precedent. It was finally overruled in the case of Maneka Gandhi versus Union of India, as I previously mentioned, in the year 1978. Maneka Gandhi whose passport issued under the Passport Act was taken away, and she received a letter from the regional passport officer in New Delhi stating that she was ordered to relinquish her passport in the public interest under Section 310 subclause 3 subclause C of the Act within 7 days of receiving the letter. She inquired the reasons for the relinquishment of her passport On the passport authorities, on the other hand, said that reasons could not be revealed because it was in the interest of the general public. In response to the writ petition filed by her under Article 32, this particular section, that is Section 10, Clause 3, Subclause C, was declared as unconstitutional, citing violations under Articles 14, 19, and 21 of the Constitution. Therefore, the court declared this particular act in question, this particular section of the act in question, to be violative in nature. In this particular case, the doctrine of due process was applied, and therefore had emphasized the reasonability behind the law to be important and not just the procedure. If the law itself is void, if the law itself goes against the rights of the human beings, then in such a case, the reasonability of the law comes at stake. Therefore, with regards to Article 21, the court held that even though the phase in the Article 21 is procedure established by law instead of the due process of law, as found in the American Constitution, the procedure must be free from any sort of arbitrariness and irrationality. Thus, establishing a rationale in India as procedure established by law, plus the procedure should be plain, non arbitrary, and very rational. Therefore, in conclusion, we can state that this formula in essence is the doctrine of due process. That is, following a procedure, following a due process in order to see the procedure established by law. We can safely conclude that the doctrine of due process isn't completely as implemented as it is implemented in USA, but the driving forces behind this doctrine is followed in India, and thus the rights of people in India are also safeguarded by the way of this doctrine. Thank you.